So a transition plan sets out a company's targets, actions and resources for the low carbon transition. But transition plan regulation is in a state of flux. We have disclosure requirements built into the global baseline provided by ISSB. We have a reopening of the discussion at EU level in the context of the omnibus. And we wait for a signal from government in the UK about the possible shape of UK regulation. All at a time when we need to urgently pull every lever we can for climate action, including private sector climate action. I'm Robert Clarke. I'm a senior lawyer in the accountable finance team at ClientEarth, a legal environmental non-profit using the power of law to protect people and planet. In our team, we work towards a more sustainable financial system through the lens of corporate and financial law. And I'm joined by three very expert panelists steeped in transition planning, climate policy and law. We have Vanessa Williams, former sustainability partner at Linklaters. Vanessa chaired the UK Transition Finance Market Review and is a member of the Transition Finance Council. We have Tom Tayler, head of international sustainability policy advocacy at Aviva. And in that capacity, he contributes to many fora and expert groups on climate change and sustainable finance. And we have Andrew Thompson, KC, who's a specialist commercial barrister at Erskine Chambers, and with his colleagues, Philip Morrison and Lily Church, authored the opinion we'll discuss a bit later on in this session. So, I don't know if that was speakers kicking in. So in a moment, we'll get into the legal and regulatory landscape for transition planning, where we are now, what to expect in future, why regulation is needed, and how to make sure transition is embedded in business strategy. And we'll specifically cover the relationship between transition plan disclosure and legal risk. At ClientEarth, we think that's something that needs to be much better understood. And in that context, later on, Andrew's going to introduce his legal opinion, which was recently commissioned by ClientEarth. We've got 40 minutes for discussion. We're starting a little bit late. We might run over a little bit, and 20 minutes for questions. I've got a bit of housekeeping to do first. Please stay afterwards to carry the conversation on with more breakfast. We've got the space until 11. We're not expecting a fire drill. So if there's an alarm, treat it like an emergency. Don't use the lift, follow the signs. This is being recorded, I think, still, and should be available. A link should be available to those who need it in the next few days. And then finally, we're going to send the legal opinion to everyone afterwards. So please do have a look in detail after the session. But first, I think let's spend some time building a shared understanding of the transition plan regulatory landscape and practice we've seen so far, UK and internationally. And I was going to start with Vanessa, and I wonder if you could share a bit of your experience working on this stuff and set the scene for us with your perspective on where we are now in regulation and what we're seeing in practice.
All righty, thank you very much. Thank you for having me. And really good opinion, so thank you for that. So if I start with transition planning is originally a UK idea that was generated and announced for the purposes of COP26. It was announced at COP26. And the Transition Plan Task Force was set up under the aegis of, I think it was HMT and DESNES. You probably remember more than me. And I got involved in spring 2022. So when they formed a delivery group. And the way in which the TPT worked was it was set up and developed as an idea of government. It was the work was done by a mix of business. So it was informed by business, civil society, some regulator presence, but it was basically written with input from financial institutions, particularly financial institutions, but also real economy companies. And if you remember, the first work was around building a disclosure framework, which was consulted, the first draft was consulted upon, and then it was finalised in October 2023. It was a big thing at the Guildhall. And then we did sector specific guidance. I chaired the oil and gas sector working group with Bruce Duguid from Federated Hermes, and that was all public. That was consulted upon again, and then published in final form in April 2024. And the materials of TPT were then transferred to the ISSB. And we had anticipated, I think already in spring 2023, that we would have the TPT disclosure framework woven into guidance supporting the listing rules by 2024, and then the election happened and things got a bit stuck. Where we are now is that we're waiting for a consultation from the UK government. That would contemplate regulation as well as FCA guidance or changes to the listing rules. And that is partly because in the Labour manifesto there was an expectation of introducing mandatory transition plans for large listed companies that were 1.5 degree aligned. And I think probably that is an issue that has put a bit of grit in the oyster, because the more you poke at that, that's quite hard to do. So separately from that, the TPT is reshaped, or at least that some of the groups supporting TPT reshaped into the ITPN, because we love an acronym here, International Transition Planning Network. And they have been working internationally, as the label suggests, with other jurisdictions that are thinking about transition planning. So currently docked into ISSB. Lots of people will have seen the announcement yesterday that ISSB have put out a whole bunch of materials that derive from TPT materials, but dock in better to their S2 standard. So lots happening internationally. Bit of a pause here, EU having a slightly neurotic think about what they're going to do.
No, thank you. And I wonder, maybe Tom, you could give your perspective on where we're at. I mean, we'd be interested in the investor perspective on what's happening, both regulation and what you're seeing in practice, but also your own reflections on maybe what's needed from regulation in that context.
Yeah, thank you, Rob. Really, really pleased to be here. See so much interest in this important issue, and looking forward to hearing the overview of the opinion, which I think is a really important step here. In some ways, Aviva were yeah. My role at Aviva involves engaging with policymakers, regulators, peers to work out how we make the shift to a more sustainable financial system. And the fact that Aviva is positive on the idea of transition planning isn't a great shock to people who've been looking in this world. We engaged before Glasgow to push the government on this idea. We were really pleased when then Chancellor Rishi Sunak announced that this was going to happen, as Vanessa said. And then our CEO Amanda Blanc co-chaired the Transition Plan Task Force, and lots of my colleagues and I did lots of work in respect of that. But at a kind of higher level, thinking about as an investor who invests globally across corporates, sovereigns, and so on, and also as an insurer that underwrites a lot of commercial activity. If we think back to what now perhaps seem like slightly easier times in 2021, certainly from a kind of consensus around some of this, we had this enormous push for Glasgow to bring the private sector into the kind of solutions to how are we going to make the transition work. And lots of financial institutions, corporates, cities, all said, we are going to make a commitment and work out how we can contribute. And where transition planning then docks in is, once you have said you're going to try and do something, you need to work out how you're going to go about achieving it. And that's where transition planning is incredibly useful, because not only as an entity from a strategic point of view, and it's really important that we try and encourage transition planning to be thought of as a strategic exercise, not a disclosure tick box. But from a strategic point of view, if you want to do anything in a large corporate or any large organization, you need some sort of delivery plan. But as an investor, if we want to think about how to understand the risks and opportunities of the transition, not just the climate transition, but also thinking about how we safeguard nature, how we think about social transition, all of those elements that are built into a holistic plan or strategic and rounded, which is one there for all the TPT people in the audience, approach to this, we need to see, for those who are asking us to deploy ultimately other people's money into these businesses, do they have a plan for what we are seeing as an increasingly volatile, unpredictable transition? And as now Canadian Prime Minister Mark Carney pithily said, plan beats no plan. And in this situation where you have, you have policy shifts that it's not just going in one direction. You've got economic and geopolitical challenges that actually having a plan, even if that is your starting point and you think, okay, circumstances have changed, therefore we might need to do things a little bit differently, either on the upside or the downside. Having a plan as a strategic tether is actually incredibly important. There's also a wider role, I think, that as the frameworks that TPT, now ITPN and ISSB have put out, there are really important things that a strategic approach to transition planning can do. And one of them is thinking about not only what can you do, but what are your assumptions and dependencies? What do you need from others? And particularly thinking about my role, which is, as I said, engaging with governments, with policymakers. We have in our transition plan set out the key assumptions and dependencies we have for achieving our sustainability ambition. And that now forms the starting point for thinking about how do we form our engagement, what are we prioritizing in terms of our policy engagement and so on. But actually, as we've said, and I know that others, including CTEX at LSE, have taken on this idea of creating a series of reinforcing feedback loops between what we see in corporate transition plans, what we see in financial sector transition plans, and what we see, whether you call it a national transition plan, whether you call it a carbon budget delivery plan, whatever we see from government, allowing that to be informed by the assumptions and dependencies from each sector as we in the private sector push for sectoral roadmaps from governments to underpin NDCs and NBSAPs and other strategic and growth priorities. Those reinforcing feedback loops, creating that transition planning ecosystem is incredibly important to understanding what the state of the transition is at any one point, where things might go in the future, and therefore where we can put capital. So I think the need to continue to push for transition planning to be better embedded. There are already lots of entities that are doing it, but also far more that are just sort of dipping their toe or haven't yet been public about the planning that they're doing. And I think that's why, and I know we'll get on to the questions of legal liability and the importance of the strategic publication of these plans, but that's why I think this is so important, because it's now a critical piece of information for investors, for lenders, for underwriters to understand. If you want our money or if you want us to take on underwriting risk, how are you prepared for the transition?
No, thank you. I think that flow of information from the corporate plan up to policymakers was a really compelling part of the TPT framework, I think. And I wonder, before we move on to think more explicitly about legal risk, I wonder, just to pause on the need for regulation. You mentioned the need to push further beyond current practice. I wonder, Vanessa, is that also your feeling, that it's the regulation that will standardise, make things comparable, push uptake further, or are we seeing enough already?
So, if you look at where we are at the moment, we have got the TCFD regime, which people are having to comply with if they are above a certain size in terms of private companies and for many financial institutions and listed companies. This is a build on that. It's actually, if you take away the 1.5 piece, a structured way of thinking about how transition affects your strategy. I agree, it's all about strategy. So it's a build on where we are in it currently. But in relation to the flow of capital, when we were doing the transition finance market review, we saw the mandating of transition plans and transition plan disclosure as an important part of enabling capital to flow to support transition at entity level, so general purpose or investments into entities. And that is super important from a financing perspective, because at the moment many institutions are looking primarily at project level, and that means less capital is flowing. So in order to unlock the system and make it work properly, we do need that additional strategic information. And yes, regulation, I think, is the way through.
Thank you.
And if I can just build on what Vanessa said there, I mean, TCFD is an interesting example, and I think transition planning is a really important complement to TCFD. So if TCFD is your backward-looking risk disclosure, but doesn't actually make you commit to do anything, the forward-looking is really important. And we know that because of now the speed and probably uncertainty with which the transition needs to unfold, that actually backward-looking data was probably less useful to us than it ever has been in the past. We need to look forward, and the forward-looking nature of transition planning means that it's a critical sort of missing piece. And what we saw with TCFD is you start off with a group of experts setting a framework. You get early adopters who will iterate on it and work out how it can happen, and then you get to a point where regulation is needed to level the playing field at a baseline and bring up those who aren't going to do it voluntarily. And we're at the same space now with transition planning, and I think it is critical. We are seeing those who, some who are now on their third transition plan, those who are working with it. What we hear, and it's our own experience, is that it's not a straightforward exercise, that it takes resource, that it takes time, but actually everybody we've spoken to and our own experience is that it's hugely worthwhile, and that every entity I've spoken to has said it is a benefit having been through that process. We understand our business better, we understand risks and opportunities better, and it has been an incredibly important tool to upskill senior managers and each part of a business as to how it's going to work. But I think you do need that regulatory nudge to make that happen, because it involves resource, it involves time, it involves management time, and therefore if you're doing it voluntarily, you might see, particularly in cost-constrained environment, that's something that people say, well, maybe we'll leave it another year, or maybe unless you have that nudge from regulation. And I think the way that the UK government rolled out TCFD, where they gave a really clear roadmap as to this is how it's going to apply to which entity and when, to get rid of that, but I'm an SME, it's not going to, I'm not ready to do this, or, how's it going to apply at different levels, was incredibly important. And I hope that they'll do something similar as they roll out transition plan.
And we recommended that in the review.
No, thank you. And that's a good segue. And I think we should move the discussion on now to, explicitly think about the relationship with legal risk, which goes both ways. And I think we'll bring Andrew in just a second, but I probably need to give ClientEarth's starting point on this just for context, and totally aligned on the need for regulation. And it's great to hear it put like that, about the need to push through into forward-looking information, because I think that's especially relevant in this context. So in our work on this, we saw lots of companies supporting transition planning, engaging in it, but also some with concerns. And those concerns include the idea that disclosing a transition plan, especially the forward-looking information Tom mentioned, your plans, targets, what have you, could lead to an unacceptable heightened liability risk. And we thought, legal organisation, we thought that's a really important point, and we need to understand if that is supported by the law, and alert that if that is something taken out of proportion, it could really impede good rulemaking, but also kind of fulsome engagement with the transition planning exercise. So we also thought an opportunity to ground that discussion in a really good analysis of the law. And so that's where Andrew and his team come in, and we instructed Andrew to investigate and provide a legal opinion on this topic. So I'll bring Andrew in, but I can't do that without just saying what a pleasure it's been to work with Andrew and the team, and how grateful we are for all the work. But yeah, Andrew, I wonder if you could tell us about your expertise, your angle on this, and then give us kind of the context for disclosure rules and liability standards around disclosure that already exists. Because I think we talked about needing to understand that before we understand how a new requirement could slot in.
Yeah, certainly. Well, good morning, everyone. I think I'm probably the odd one out in the room in that I'm not an expert in climate policy, but a company lawyer, which is why ClientEarth asked me to work on this. Now, as Rob says, the important thing first is just to think about the legal context, because we're not anticipating that any new forms of liability will be introduced specifically to deal with any requirement to disclose transition plans. Instead, this new requirement to disclose will be effectively injected into an existing legal framework. And so let's just think for a moment about what that framework is, what the relevant parts of the law really are here. And we're really thinking about the law of misrepresentation, because we're looking at potential liability here for false statements. Now, I'm not going to give you a lecture on the English law of misrepresentation at 9 o'clock in the morning, but just to give you the important context here. This sort of liability arises in relation to statements, normally statements of present fact. And as Rob says, we're looking here to a large extent about forward-looking statements in transition plans. Now, in relation to forward-looking statements, there are existing forward-looking statements that are required. And what the law basically says in relation to forward-looking statements is that there isn't a liability for turning out to be wrong in making a forward-looking statement. So if I express an opinion as to what's going to happen in the test match at Headingley today, and it's totally wrong, well, there's no liability attached to that. But what the law does attach liability to is any implied statement of fact, present fact, that is made alongside the forward-looking statement. So if I express an opinion as to what's going to happen in the future, first, I'm probably impliedly representing that it's genuine. I genuinely think that. And secondly, I may well be impliedly stating that I've got some reasonable basis for it. And so that's the sort of liability we're looking at here. And I'd just like to flag a few important distinctions here. I mean, we're looking at the liabilities of companies and directors, and there are differences between the two. Differences between the liability of the corporation and the personal liability of directors. It's also important to look at who might make claims, and just as a matter of generality, investors are more likely, as a matter of law, to have avenues to make claims. We've also got to look at which companies may end up making statements which give rise to liabilities. And the existing law certainly puts a greater burden, for example, on listed companies and large private companies. But a really important distinction here, which I'll close on, is as regards the basis of liability, the basis of culpability. And the important distinction here, and it's very important in this context, is between liability for dishonesty and liability for mere negligence. And a lot of the existing framework gives rise to liability for dishonesty, but not negligence. Now, negligence liability for misstatements does exist, but it's far less widespread. So that's really the basic framework into which this is going to be injected. And later I'll come on to describe how I think that applies to forward-looking statements, in particular in transition plans.
No, brilliant. Thank you, Andrew. And I wonder, maybe you could just say a little more about how the dishonesty standard is struck, just in general, terms?
Yeah, I glibly talk about dishonesty, but what it actually means generally as a matter of law in relation to a false statement is that the maker of the statement doesn't have an honest belief in its truth. Now, that could be in the very straightforward way because the maker of the statement knows it's not true. It's a lie, a straightforward lie. But it can also arise when the maker of the statement is reckless as to the truth of the statement. What that means is he or she doesn't know that it's actually false, doesn't know whether it's true, hasn't investigated, makes the statement anyway. And that's dishonest as well. And that's probably an important point in this context. Thank you, Rob. Yeah.
No, thank you. And so we should go on to the opinion and how that framework applies or could apply to transition planning statements. I wonder very quickly first, Vanessa, Tom, you have your ears to the ground in what's happening in practice, and I just wonder what your perception is of how legal risk is being thought about. Does it resonate how open this session, or are you hearing other concerns? I think just understanding how companies are feeling about it would be a good place to be before we then go into the analysis a bit more.
Shall I start? So I think that if you are a company, you're going to be very careful about how you articulate what your transition strategy is. Now, if you engage with the TPT framework, or what ISSB has now done, that guides you into an articulation, not just of what your overarching ambition is, but then into a granular explanation of what are the levers that you've got that you can deploy to try to deliver against shorter term targets, which may be emissions, but they may be other targets as well. But it also pulls out of you or asks you to think about the assumptions and to disclose the assumptions that you've made and the dependencies inherent in your ability to deliver. And that piece in relation to assumptions and dependencies is an important, really important area that a lot of work's going on to develop in universities and amongst policy people, because it's at the heart of the limitations around what companies can do. Now, if you are a non-executive director or an executive director, you will be concerned, I think, and particularly for non-executives. We are covering a big suite of issues. It's quite hard being a non-executive at the moment. There are a lot of moving parts. This is one of them. It's a technical area. So I think there is the legal analysis in terms of disclosure risk, but as a director, you will be thinking about the risks and opportunities that the business of which you're a director faces in relation to climate, the substantive risks and opportunities. And you will also be thinking about how to characterise that in your existing disclosure, or if you develop a transition plan. In a technical area which you may not understand very well, you're going to be super cautious, particularly given the litigation and the noise around people misstepping, so greenwashing risk. So I think on top of the legal stuff, we need to think about sentiment. And there is a responsibility on everybody to think about not just what the liability analysis is, because that's the top of the pyramid of doom, but also what are the other bad things that could happen that act as disincentives to engage with this. There are real risks with disengagement, because actually there's a very strong argument that you make, I think, that if you go through a disclosure framework, it requires you to think more precisely, and so your disclosure ends up being better. But it's quite human to think, oh God, this is really, really hard. Do we have to do it right now? And that's the bit that we all need to navigate quite carefully.
I mean, I think one of the reasons that I'm really pleased that this opinion's being commissioned and being published is there genuinely is nervousness, right? There is nervousness around senior leaders, directors around this, right? So giving comfort that actually this is an area where existing regimes that they are familiar with can cover the things they're being asked to do, I think is really important. So as a large listed entity, anything that we put out to the market is rightly scrutinised, right? So that as a starting point is familiar, right? You have to make sure that you have a basis to make any statement to the market. And it's not to say there is no risk in doing a transition plan. That's not where there is risk that is mitigatable, if that's a word, by familiar structure, by making sure you have a reasonable basis for what you've put in, by basically doing the work to underpin what you put out to the market. Because actually businesses put forward uncertain information out to the market all the time. Right, in your management report, you're likely to say, here's the next 3 years of anticipated profits and dividend. Right, what you undertake to do when you do that is that if circumstances change so that information previously put out to the market creates a misleading impression, you undertake to correct it. So essentially, if you report on how you're progressing with your transition plan, you create that update as to where you are and whether any circumstances have changed. Similarly, Aviva is a large life insurer. Right, the forward information we put out is dependent on actuarial assumptions about how long people are going to live that go way into the future. So forward-looking uncertainty isn't unique either, even though that is often cited as one of the problems in putting out a transition plan. So the key thing is, in an area that I agree with Vanessa, in an area where there is perhaps nervousness around new information, new forms of disclosure, giving comfort that familiar rules and familiar ways of making sure that you have a reasonable basis for what you're saying, I think is the right approach here. The other thing that I think is really, really important, as we see increased policy measures being put in place, insufficient, unfortunately, so far, but increased policy measures put in place, the transition start to accelerate. Actually not doing anything also carries risk. Yeah. So where you're nervous, thinking, I'm going to retreat into my shell, I'm not going to do a transition plan, I'm not going to publish anything, that will keep me safe, is the wrong approach here. Because at some point you will come to the stage where, whether it's your investors and stakeholders or whether it comes into legal liability, saying, how come you haven't got a strategic plan for the biggest geoeconomic, macroeconomic shift that's happening probably in history? Right, and at that point, are you fulfilling your duties as a director to the company, to the shareholders, or so not doing anything is also a risk, and I think that's one of the reasons that getting people comfortable with doing something is really, really important.
Yeah, no, thank you. That's super helpful, both, and I think we're getting into a topic we can come back to with kind of really rich reflections about how risk should be maybe reappraised in light of the legal work and what companies can do to ensure the plan addresses those things and mitigates risk. But for an understanding of existing standards is the perfect segue, really. And I think we should take a bit of time for Andrew to talk us through the exercise and the key conclusions. We're running a little behind, so I think we might quickly go into questions after that to make sure there is time for questions.
I can be brief.
No, I mean
it's a lengthy opinion, but let me summarise it. The key question we were asked was, what will this result in expanded risk of liability for companies and directors? And the short answer is, in our opinion, no. Let me explain. Here we're assuming that the requirements of a transition plan will basically reflect the TPT framework and IFRS S2. And what we've got to look at, therefore, is what sort of statements are going to be required and which statements of that sort are going to give rise to liability. And we really distilled it down to three types of statement. There will be targets, so objectives. There will be statements which are plans, so the steps to get to that objective. And there are requirements for certain expressions of expectation, so what certain steps may well contribute to the target. And those are the three areas to focus on. And in all respects, they are really forward-looking statements. But they all have the sort of implied statement of present fact potentially coming with them that I referred to earlier. So if you just take targets and plans for a moment. If you identify a target, you will almost certainly say that that is genuinely something you're going to pursue. You intend to pursue. You will probably impliedly be saying that it is, at least in your opinion, a reasonably feasible target. And you may be stating that you've got some sort of basis for that. And if you look at plans, so the steps you're going to take, again, you're going to be stating an intention to actually do that. And you're probably going to be impliedly stating that you believe at least that it's a feasible step in each case to take. So those are the sorts of implied statements that could in principle give rise to liability. But what we've got to look at then is, well, how likely is that? Well, first, of course, that statement that you make of that sort must be false. It must not be true. So if you do genuinely intend to do these things and you do have a reasonable basis for it, the statement that you might be making is not false. So any claim fails at the first hurdle. There's then the question of, well, if it is false, are you actually culpable? Now let's assume a dishonesty standard that I described earlier applies. So first you've got to realise that you were making that statement. You can't be dishonestly making a statement if you don't know you're saying it. But secondly, more importantly, you can see that these statements may well be quite hard. It may be quite hard in relation to these statements for claimants to show that directors were acting dishonestly, even in the reckless sense. Because we've got to look at, well, how might this arise? How might a statement be made dishonestly in this way? If you're making an implied statement about the feasibility of taking a step in your transition plan, your statement, as I say, is likely to be that you consider it to be a feasible step, and perhaps that you have reasonable grounds for considering that. But if you've actually done some work and perhaps taken some advice, and you genuinely believe it is indeed a feasible step, there's no question of any liability, because we're dealing with a standard of dishonesty. And it's really in situations where directors may be really plucking figures out of the air, for example, in setting up targets, or setting out plans, steps they intend to take, where they haven't actually done any work to establish that that is something that can actually be done, where liability may arise. So we're talking about relatively extreme situations here. I mean, just putting it very, very succinctly, it almost amounts to don't pluck figures out of the air and don't make stuff up. So that's the main. Now that's dealt with very briefly, but that's the main point. And I can go on to talk about safe harbours and some of the potential benefits.
I think that would be good. Yeah.
I know you want to move on, so
No. I think we're giving this plenty of time. It would just we might build in some of the reflections into the questions, but sure. I think take your time and through it.
I mean, another question asked is, well, is there a need for more safe harbours? The idea of a safe harbour in law was the idea that the law establishes certain circumstances where there won't be liability in order to reassure people such as directors who are exposed to potential liability otherwise. And we already have a very important safe harbour here, which is section 463 of the Companies Act, which applies to directors, which basically says in relation to, for example, statements in the strategic report, that directors won't be liable to anyone other than the company, and they will only be liable to the company if they're dishonest. So we already have a very important safe harbour here for directors, for example. There are also safe harbours in relation to companies, in relation to FISMA, and the basic conclusion here is that there are already ample provisions for safe harbours which do not need to be added to. Ultimately, a safe harbour question is a policy question. You might want, on the one hand, to reassure directors or others who are feeling exposed. But on the other hand, of course, if you have a requirement, you have to have some sort of teeth potentially available to enforce it. And so if the safe harbours are too big, effectively it takes away the obligation that you've imposed in law in the first place. So there's a balance to be struck. The basic point is that the balance has already been struck in relation to forward-looking statements, in relation to companies and directors, and there isn't any need to do it differently in relation to any requirement to disclose transition plans. And then the third question, just very quickly, that we were asked was to look at whether there are any potential advantages in being required to disclose a transition plan in terms of legal liability. And Tom actually touched on one already. I mean, and Vanessa actually on another. I mean, there exists already in law a requirement as part of the strategic report for listed companies and large private companies to make various disclosures in relation to the effect of the climate transition on them, and what disclosing a transition plan requires one to do is to actually be much more precise. And so actually, one is already exposed to potential liability as a company or director, and by being required to do something more rigorous and more precise, that potential exposure, in my opinion, is reduced, certainly isn't increased. And the other point is just generally in relation to directors' duties and directors' liabilities to companies, because, as Tom describes it, companies are facing, whatever sector they're in, a very dramatic strategic economic change. That is something that, just complying with their ordinary directors' duties, directors have got to think about in a strategic fashion. And if this helps them do it, it is likely to reduce their own potential liabilities that might flow from failing to do so. So that's a real nutshell description of what the opinion says. Probably far more useful than the opinion itself.
No, I mean, that's fantastic, and it's covering a lot of ground that is backed by a huge amount of analysis in the document. So please do have a look afterwards. I think I wanted to give Vanessa and Tom the chance to reflect on that before going into questions. I think we might, if it's okay to run over a little bit, we can still give 15 minutes or so for questions, and I think that's really important. But I might just, if you have very quick reflections first, by all means come in. Otherwise, we can go to the floor.
Nothing to add from me.
I mean, I think yeah. Don't make stuff up is a really good rule of thumb that I think we would stick to. I love and I endorse what Andrew said about don't do things differently for climate or transition planning. Right. What we need to get to is where this is an integral part of how we do business. So I think that's really important. I think creating a golden thread of consistency from the management report, the transition plan, and actually the financial reporting is really, really important. So you don't have different information in the management report to what you're saying in your transition plan, and crucially that it follows through to everything you're putting in your financial reporting about how you're thinking about that. And we are seeing in some places disconnects between that, which is a different stream of work, but very, very important. And then the last thing I would say, just with my kind of investor hat on, and thinking about why this is so important, not having the information about how businesses are intending to go about strategically transitioning actually undermines our ability to assess and price risk. It undermines the price formation process. It undermines the integrity of the market. It undermines fair competition because you don't have equality of information between market participants, and it undermines consumer protection because we don't know where we're putting our beneficiaries' money, or for consumers, they don't have the information to choose where they deploy their resources as systems. And funnily enough, those are the three strategic aims of the financial service, FCA. So the reason behind this is that it's just part of how an effective market in transition needs to work.
No, thank you. A little bit important then. That's fantastic, and I won't take up any time kind of playing that back at all. I think we wanted this to be the start of a debate that is more grounded in the law. It's a debate, it has two sides, but just providing a bit of balance and starting a conversation about this that kind of endures and leads to a more balanced kind of perception of how this all works. And so I think we should allow ample time for questions. We can do 15 minutes or so. We have Ali and Abby in the room with roving mics. I think we're going to take groups of 3 questions. If you can keep it brief, introduce yourself, please, and if you want to direct it to one or other panelist, please do. That's helpful too. So we'll take 3, and then we'll address them.
Hi, my name's Fergus Green. I'm an associate professor in the UCL Department of Political Science and School of Public Policy. This has been really insightful. Thank you. Both Tom and Vanessa mentioned assumptions and dependencies. And I wanted to ask about the sort of dependency aspect. And Tom, you mentioned how this sort of underpins your policy engagement and public engagement. So the context for the question is really a lot of academics and probably others, and I'm an academic, so that's what I read, are sort of critical of the kind of procedural thrust of a lot of recent climate law in the sense of the limitations of disclosure and transition plans and so on being procedural, and then sort of assuming that the market will then kind of correct and we'll get a transition, and think that actually what we really need is much more climate law and policy, substantive climate law and policy. And therefore, if you think that the most important thing that a lot of companies and a lot of investors can do, with the possible exception of the really carbon dependent companies, is actually work together to lobby and influence the public and actually get the binding laws that then apply to everyone in regard to climate. And I wondered if you could just sort of say a little bit more about to what extent in the sort of transition planning world these kinds of things are discussed, and could more be done in that regard? Thanks.
Thank you. There's another hand, I think. Yeah.
Hi there, thank you very much. I'm Camille. I'm a finance lawyer at Weil Gotshal. Maybe this is for Tom or Tom or Vanessa. On working in private practice on financing deals, we saw quite a lot of contractual provisions requiring disclosure on sustainability reports and not much on transition reports. And I think in the last 12 months, a lot less of these contractual requirements. I'm just wondering, as we're advocating for regulation to increase and more disclosure to continue, if the contractual lever that, say, lenders might have or managers towards their portfolio companies could have, if that's something that you're seeing in your day-to-day or elsewhere, maybe not so much in what I've seen, but it'd be interesting to see what your thoughts are on that.
Thank you. Well, lots of hands going up. Some at the back came up.
Thanks very much to the panel. I'm Jacques Morris from the ITPN that Vanessa mentioned and former TPT team. I found this incredibly useful and valuable. As far as I understand, this is a UK-based opinion. Do you have any views on applications in other jurisdictions?
Thank you. Good first set of 3. So we've got assumptions and dependencies disclosures, the limits of disclosure, and the need for advocacy for real policy and how that comes in. We've got the contractual angle and how contractual disclosure requests might link in relation to transition plan disclosure. And we've got the UK versus other jurisdictions point. Does anyone want to start with any of those?
Shall I start with some of those? So on assumptions and dependencies, you're right, we need real economy policy, and actually we need some adjustment to financial regulatory policy as well. We cover that in an awful lot of detail in the Transition Finance Market Review. Dependencies within a transition planning framework have the capacity to inform government as well as being useful for investors in terms of understanding the assumptions on which the entity is proposing, is basing its transition strategy, and the dependency. So it gives information to policymakers. It gives information that may then shape policy advocacy, both at the real economy and at the financial level. So it's useful, but definitely there's a need for real economy sectoral policy. Financing, particularly, we see side letters in the private capital space. I suspect you might have seen a bit less because of the overall sentiment that's coming out of some parts of the market and the need to sort of retrench a little bit but I think that will continue in various fits and starts. So I think you will still see that. If once we get better information in the market, then actually that ought to start unlocking a more consistent, comparable data set, and that starts to self-correct, and you probably see the tailing off of information-related contractual provisions or the standardisation of them.
So for my part, Fergus, yes, agree with you. Of course, we know that we have a misalignment of current stated policies and what we need. I think my view is that for each dependency that you set out, there then should be a corollary of that you're going to go out and raise your voice as loud as you can to call for the things that you say you need. So we saw in every of the net zero alliances, it says we make our pledges on the basis we expect governments to deliver Paris. What I think needs to follow is we will therefore shout as loud as we can to say, please can you, this year, please can you put in place 2035 NDCs that align with a 50% cut in emissions by kind of the midpoint 2030. And we are seeing more of that, but we're not where we need to be. And that's part, I think, of also making your transition plan part of your overall business strategy. So aligning all of your advocacy with what you're putting in your transition plan as is relevant. I mean, I think, yes, Vanessa mentions in the TFMR, one of my favourite lines, and there are many, is that there's a statement that says those who want the transition need to go out and advocate for it in the best interests of their beneficiaries and customers. And I think that's incredibly important. Yes, there is the kind of the bilateral element. I remember in Sharm el-Sheikh, the CEO of one of the world's biggest banks saying he wanted to get to a stage where the first thing that they asked for from anyone who wanted their capital is, what's your transition plan? But he recognised we are not there yet. So yes, I think there is opportunity for bilateral calls for this information, but I do think that what we need is that regulatory baseline, which means that information is then available to all to help inform it. And I noticed that both Vanessa and I have strategically ducked the jurisdictional question, which I think we're going to hand over to the KC in the room.
Well, I mean, there's a matter of policy. I'm not sure I'm in a position to comment, but in terms of jurisdiction, anything that's introduced now is only going to be applicable in this jurisdiction, quite simply. And there's always a problem, not really a legal problem, a policy problem. Of course, if you introduce any legal requirement or regulatory requirement that is more demanding than the norm internationally, you will have business quite fairly complaining. And so it's extremely important, obviously at a very high level, that ideally we are not the only ones doing this.
Thank you. And I have a similar take on your question, Jack. It's great the ITPN networks like that exist to build the international picture. I think, we reacted to concerns we felt existed in the UK market. Wherever that's a concern, it would totally be really interesting and valuable to do a similar exercise and check how they align with the law. And obviously there are jurisdictional specifics, but maybe some universality to be explored there as well.
Can I just add one thing? At the moment, my real concern is that with ISSB, we're being overtaken by other countries in terms of adoption of ISSB. And because of the importance of all of this in the context of the opportunity for financing transition, if we want to be a hub, which I think we do, for transition finance, we need to be signalling that we are supporting the intellectual capital that we've spent 5 years developing. And that is now something that we need to see happening and a decision taken.
A really important note, thank you. And so we're at risk of running over, but I'm happy as long as everyone's happy to carry on. And if we can get another round in, that would be great. And there's at least 3 hands.
Hi, good morning. Thanks. Susan McCormick. I'm at MoFo. I teach at Berkeley Law School. It's, American here, so sorry about what we're doing. I just I had 2 quick things and then a question. Number one is in the U.S., I'm a company lawyer as well, and I teach corporate climate governance. But the biggest risk really we have is Sherman Act antitrust, and I wanted to know if there's been any analysis. That's sort of the biggest pushback and the biggest stick that is actually effective that's working against climate in the U.S. Second, I just, in terms of regulation, I'm an advisor to the ISSB. The more other countries pass, the more you're going to force the U.S. to capitulate because, we are part of the global market. But third, more than half of the companies, the large multinationals, that were preparing for CSRD and CSRD readiness spent so much money preparing for the regulatory disclosure. They now don't have the budget to engage in transition. And so I'm wondering if anybody is looking at that correlation. I mean, the large have spent 10, they've spent 20 million, and now their board and management are like, there's no more money left. And so I'm wondering if we're focusing on disclosure, but does disclosure actually lead to change?
Thank you. And then there's one near the front as well.
Hiya, Ben Fagan-Watson from the Department for Energy Security Net Zero. Question for Andrew. My reading of the Companies Act, section 463, is that the safe harbours apply to the director's report, the director's remuneration report, and any separate corporate governance statement. The Transition Plan Task Force guidance suggests that it might be appropriate to publish a standalone transition plan every 3 years. So would the safe harbours not apply to that standalone report?
Thanks. Mary Gilmore-Moore, Legal Director with an Environmental Asset Registry Standard. I'm particularly interested in the concept of, potential liability for dishonesty, especially recklessness, where underlying scientific concepts are very much still debated. So you can get advice, you can have auditing, certification, but underlying scientific concepts are discussed. Let's talk about, for example, permanence, additionality. So I'd like to know how that perhaps can play into potential liability under a transition plan.
Thank you. I think that's 3, isn't it? And I think there's something in there definitely for Andrew. Maybe we'll go there first. And we had one question about the limitations of the 463 safe harbour, what that applies to and doesn't, and the assumptions made in the opinion about that. But I think there might also be something there about what the TPT recommends about where the report goes and how it's integrated into the statements. But then also maybe could build into that any reflections about the nuanced application of the dishonesty standard and how that works, where scientific perceptions or, in the opinion, I know we talk about global ambition shifting, something that brings it to life with an example like that about how the standard might apply in those circumstances. And then maybe we can come back to Vanessa and Tom on that, but also on the first question about limited budget available after the pulling back of the EU requirements, what that leaves for transition planning, and how we weigh that against the limitations of disclosure. But maybe the legal bits first.
Okay, on section 463, the position on section 463 at the moment is that if one is a company that is required to, in a strategic report, make disclosures in relation to climate, then section 463 will apply there. Now, it's absolutely right that it's not at the moment clear, of course, we haven't even seen the consultation document, in what form precisely a transition plan might be required in future to be disclosed. And in the opinion, we've assumed that that's either going to be as part of the strategic report, or if separately, that section 463 will be extended to apply to it. And the reason we made that assumption is that, of course, the strategic report, where climate-related disclosures are required, does actually cover at a rather more high level the sort of things that would go in a transition plan anyway. So there would be a certain logic in extending 463 to cover. So that's the assumption we've made, but the ball's rather more in the government's court on that one rather than mine. In relation to scientific developments, and obviously the science is very important, but of course the critical point is that in terms of liability, just focusing on liability, one is looking at the present statements, so statements made at the time that the plan is arrived at and disclosed. And so future developments of scientific understanding are inherently not going to trip up the makers of the plan, because they will be future and they won't be relevant to assessing the statements of fact made at the time. So they're important, but they're not relevant to liability.
Thank you. And yeah, Tom?
Yeah, happy to. So first thing I'd say, Susan, is I really recommend you talk to Maurits Dolmans, who's sitting in the second row, about antitrust. But on that issue, so again, we've got a UK opinion. Obviously, the state-led nature of some of the antitrust in the US we've seen that with letters from state attorneys general to insurance companies and others. There's a nuance there. But in the UK and EU, we have a lot more comfort from the regulators on positive collaboration on sustainability. So I think that is positive. We shouldn't pretend that market participants don't get together and collaborate in the public interest on all sorts of things. Antitrust is important to protect consumers from anti-competitive practice, but coming together to solve difficult questions together is something that we've done many, many times, whether in sustainability or non-sustainability. So a recent example is, for example, the way that market participants came together to move from LIBOR to SONIA. There was a huge amount of collaboration there with support from government and regulators. That wasn't anti-competitive. That was solving a tricky market-related problem. And obviously, if we get to the stage where this becomes a regulatory requirement, you're not being anti-competitive if you're complying with a regulatory requirement. In relation to your question on disclosure, I think this is one of the keys why this is seen as a strategic exercise, not a disclosure obligation, although you have to disclose something at the end of it. Where recognising that budgets have been spent, ultimately, if we get to a stage where the better, more comprehensive your transition plan, the easier it is for you to secure long-term finance and the lower your cost of capital, which is how I think this should work, then the upside in doing a good job should overcome any costs incurred in doing so.
Thank you. Did you want to come in, Vanessa?
Simply to acknowledge the real pain that a whole bunch of companies have felt in relation to CSRD and CS3D. But to say that some of that work is actually capable of being deployed through a transition strategy. And having a clear roadmap will, I think, help different types of company and financial institution understand where their delivery and disclosure obligation comes in. So I think a more structured, tighter focus on transition planning will help. But yeah, I recognise that this has been a bruising experience, and it's been a bruising experience at all levels of organisations. I think we just have to acknowledge that this is a difficult area, and no criticism actually to the EU. They were first mover, and they developed a bunch of thinking that has shaped the market. There is a separate question as to whether using disclosure quite so much as a lever is appropriate. But it was a way through when governments did not feel at that point able to act, or did not act, in relation to the development of many real economy sector policy areas. So it's a bridge.
Thank you. I think we should think we should bring it to a close there. We're a bit over, but we've got the space outside till 11. I think that was a super rich discussion and hopefully really helpful. We've heard lots. Just to pick out a few bits, we've had the opportunity for government and not being outpaced by adoption of ISSB in other places. We've had the need for regulation to push a kind of consistent approach to forward statements and a commitment of resources. We've rooted that in a better understanding of the dishonesty standard and what that means. And we've had bits of advice on how to approach that assessment. We've had don't make stuff up. But we've had the important point that it can in a way be approached like any other disclosure. And some of these rules are long-standing and have existing interpretation and existing processes can stand companies in good stead. So I think we'll stop there and hopefully we can carry on with some of the difficult questions outside. I want to thank everyone for coming here and online. I want to really acknowledge and thank the wonderful ClientEarth team that's made the event happen and all of our external partners that have helped with this work a lot along the way as well. But yeah, finally to give some applause and acknowledge our great panelists, Tom, Vanessa and Andrew.